It has been a huge few weeks in New Zealand politics. As the government's Treaty Principles Bill passed its first reading, it was greeted by protest inside the House and a hikoi to the steps of Parliament. They came in their tens of thousands.
How would you compare this to the foreshore and seabed hikoi?
Oh, look, with respect, this is huge. This is a lot more. This is exactly what our people who started foreshore and seabed were looking for, and they will be saying, wow.
An historically large hikoi to the steps of Parliament.
This is to say that we support Māori and we support the treaty, and we think what David Seymour is trying to do is outrageous.
Spilling out over the streets in the centre of our capital city.
And when they say kill the bill, I say read the bill, debate the bill, and help build a better New Zealand based on universal human rights.
But despite the public opposition, David Seymour's bill is now before the Select Committee as he seeks to establish a legislative definition of the treaty principles. And here they are. Principle 1. The Government of New Zealand has full power to govern, and Parliament has full power to make laws. They do so in the best interests of everyone and in accordance with the rule of law and the maintenance of a free and democratic society. Principle 2. The Crown recognises the rights that Hapu and Iwi had when they signed the treaty, Te Tiriti. The Crown will respect and protect those rights. Those rights differ from the rights everyone has a reasonable expectation to enjoy only when they are specified in treaty settlements. And Principle 3. Everyone is equal before the law and is entitled to the equal protection and equal benefit of the law without discrimination. Everyone is entitled to the equal enjoyment of the same fundamental human rights without discrimination.
Kill the bill! Kill the bill!
Opposed by thousands in the streets, but according to Curia polling, supported by just under half of voters, with another quarter unsure. The government's voted the bill through to Select Committee. Submissions open until early next year. And with us this morning to consider the meaning, the purpose and the future of the Treaty Principles Bill is ACT Party leader and Associate Justice Minister David Seymour. Kia ora, good morning.
Good morning.
What are you trying to achieve?
We need an understanding of our founding document that's actually unifying rather than divisive. Over the past 50 years, since Parliament said there were principles but failed to say what they are, a relatively small and narrow group of New Zealanders, mainly judges, the Waitangi Tribunal, iwi leaders, some public servants in Wellington, have come up with a version of the principles that's totally inconsistent with liberal democracy. It says that there is a partnership between races, and in terms of the Court of Appeal. Other people say there's a partnership between the Crown and Māori. And the problem with that is that we look at ourselves as part of a collective based on ancestry rather than a group of individuals who have all different things about them, all different hopes and aspirations and challenges and choices, trying to overcome what they face and their time on earth to flourish in their own way. That's what we should be looking at, but instead we're told, oh, you're tangata whenua, you're tangata tiriti, you have a different role in society. Now, out of that comes a whole lot of policies like having co-governance of Three Waters, a separate Māori health authority, need to consult people on the Resource Management Act, different takes on what the history of our country is in the curriculum, different procurement by councils. You get a whole lot of issues where we need to actually get a lot better at, say, building houses or getting more jobs or doing healthcare better, but we're constantly held back by this idea that before you can take a person seriously, you've got to ask, well, you know, what's your ancestry? Which side of the treaty partnership? How should I talk to you? And you see this in the recent report by the Waitangi Tribunal on my bill, where they went and said, you know, this bill will trample all Māori. Well, hang on a second. Actually, since when do they speak for a whole race of people? Since when do all of us have to think the same and take the view that the Waitangi Tribunal thinks? I think that statement in the Waitangi Tribunal's most recent report on my bill sums up everything that is wrong with the last 50 years of the way the treaty principles have developed. And that's why I propose the principles that you've just put up on screen, and thank you for doing that. I think it's more important that people actually look at what they're saying, that the government has the right to govern and make laws. You know, that we actually have an obligation as a government to uphold people's rights, including Māori, but that all of those rights should be equal before the law.
We will look at the specificity of those definitions a bit more in a moment. Just talk to me a bit more about the harm. Where is the harm? So you're Māori, I'm not Māori. What specifically do you get today as a result of the interpretation of the treaty principles that I don't?
Well, for example, I might be consulted, at least maybe not me personally, but the people who are leaders of a Māori organisation, an iwi or runanga in my area, get consulted about development of, say, a subdivision of more houses for other people. That's, mean that they can hold it up. They have to do a cultural impact assessment. A lot of developers will tell you that that can be really grating and hold up developments for years. What that means is whether I'm Māori or you're not or whatever, I live in a country where it's harder to get homes built because we've taken a view under resource management that because the RMA has to observe or at least have reference to the principles of the Treaty of Waitangi, the councils go away and say, well, the treaty's a partnership, so therefore we have to consult.
So there's a burden that comes through consulting.
Yep,
yeah.
And so then you look at trying to get infrastructure done, you look at trying to get water treatment plants so you can have new subdivisions, so even just getting enough housing done before you get onto education, where instead of asking, well, what is actually the best knowledge in the world for the students that are going through school now to have to survive and thrive, we say, oh, well, hang on a minute, what does the treaty say? What does the partnership require? All of a sudden, you find that your school has decided to take on compulsory te reo, and whether or not you like it or want it, you're required to be pulled out of maths and English and science to do a language that only a few 100,000 people in the world actually speak. And instead of saying, well, look, I respect people's right to do it. If other people want to, they can, but no, thank you for me. You can't go down to your school and say that because people say, oh, no, you're racist.
Right.
That's the division it's led us to.
So you've said, I think, that dividing people by race and ethnicity and granting them different sets of rights or legal rights has never worked anywhere.
Yep.
What about Sweden?
What about Sweden?
Well, the Sami reindeer people have indigenous rights to herd reindeer. They have land rights, a Sami parliament. All of that's enshrined in law. Sweden's not yet a failed state.
Well, that may well be true, but I think...
What about Canada?
Well, again...
And the US, they have indigenous people have rights enshrined in law. Same with Aboriginal Australians. These aren't failed states.
Well, if you want to talk about Australia, Canada and the United States...
No, I mean, that phrase you've used a few times now, that dividing people by race and ethnicity, granting them different sets of legal rights, has never worked anywhere. I mean, there are 4 countries where it's worked.
Well, actually, I don't believe it has worked. If you want to talk about any of those countries, let's take Canada, for example, one that I happen to know a little bit about the background. The reason that people believe New Zealand has the best race relations in the world is because we've never done or never dreamed of doing what Canada's done, which is effectively put 1 million people of First Nations ancestry under INAC, or Indian and Northern Affairs Canada, and say you live on a reserve, it's governed by a band council, all of your social services are funded through one government department, and the level of poverty, dysfunction, abuse that occurs on those reserves is absolutely third world. So, the idea that somehow an American or Australian
degree of
or
sovereignty,
Canadian view... Yeah, but my thing is it doesn't work. The reason that people admire New Zealand is that compared to any of those other 3 Anglo countries, we have taken the view that all New Zealanders have equal rights. That's actually what our treaty says. In the last 50 years, we've started to go down a track that, in my view, makes us much more like Australia, Canada and the United States, where people who are of First Nations or Indigenous or Aboriginal heritage are told, no, you're in a separate basket from other citizens.
They're hardly failed states, though, are they? So why should Parliament...
Just a second, though. The question is for the people who are affected by those policies.
Well, I think many Māori would argue that actually Māori haven't benefited from the status quo in New Zealand right now. Māori are overrepresented in all the bad things, underrepresented in all the good stats in New Zealand.
Yeah, but
very quickly, though.
No, you're missing the point here. The point is there are 2 basic ways to do this. One is to have division, a different set of rights, different sovereignty, live under a different jurisdiction in a different location. That is the Australian, Canadian and American model. It's been a disaster. Are there problems in New Zealand? Yes. But our model of saying we have one standard of citizenship, we're all human rights, you all have equal rights, that is vastly superior to what they've done. My argument is the last 50 years we've become more like, not very far, but we've started to go in that direction of division. And I think we need to go back to New Zealand's true approach, which is equal rights for all.
So why should Parliament be the one to define the treaty principles?
Well, I think the fact that it's elected by all people, you've got to remember that in New Zealand today, we've got 5.3 million people from all kinds of heritage, people who've been here for 1,000 years, in the case of some of my ancestors, others who will get off the plane at Auckland Airport this morning to begin their journey as Kiwis. And between all of those, or at least for most of us, there actually isn't any other country to go back to. We're citizens of this country, and the right to vote and elect a parliament and have a say about our constitutional future, that is absolutely critical.
Do you believe in the sanctity of contract?
Yes, I do, but I also believe that contracts need to be interpreted, especially over 184 years, and you've got to balance that against the rights of people to be a thinking and valuing being with equal dignity and equal respect afforded to them in our constitutional arrangements.
But you would agree, if not a partnership between races, you would agree, I think, that the treaty is a binding agreement between iwi hapu and the Crown, right? So how would it be just for one party to an agreement to unilaterally define the meaning of that agreement without the other party's consent?
Well, that's exactly what's been happening over the past 50 years when the courts and the Waitangi Tribunal have a very narrow range of...
Respectfully, the courts aren't the Crown, though, are they?
Well, that may be true.
So the courts aren't actually one of those parties that signed the agreement. The Crown signed the agreement with iwi and hapu. Those are the two separate parties to the agreement. So the courts are the closest thing we actually have to a neutral arbiter. I mean, it is the responsibility of the courts to resolve conflicts or divisions between the Crown and other parties, which is exactly what they've been doing.
Nonetheless, what they've come up with is a version of the treaty that is completely unworkable in a liberal democratic state. I mean, we've just seen that. The best examples you can come up with are American, Canadian and Australian
Sweden,
reserves. Yeah.
So,
I mean,
the
examples you came up with are so
back
disastrous.
to that point, though. No, so I mean, I think this is a critical part of this, right? Why should the Parliament, which is the Crown, in your case you are a Minister of the Crown, why should a party that has a direct conflict of interest when it comes to the Treaty of Waitangi be the one to ultimately interpret what the treaty means without the consent of the other party?
Well, it's actually the Parliament on behalf of the people of New Zealand. And the problem with
You're a Minister of the Crown, though, right? So you are a concerned party, as opposed to the courts and the Waitangi Tribunal, which are...
Yeah,
neutral third party.
If you want to get into this three branches of government thing, sure, I'm the executive, and as a minister I introduce the bill to Parliament. It's the Parliament, which is the elected legislature of New Zealand, that is deciding whether or not it goes forward. Now,
you as a Minister of the Crown define these principles. The Crown is a concerned party when it comes to the Treaty of Waitangi, which is why, in the eyes of some, having courts be the arbiter of this might be more appropriate. I mean, if you think about other contracts, right, if it was like, I appreciate it's different, but a car loan or a mortgage or a custody agreement, it would be totally unjust for one party to unilaterally decide what that agreement means.
Well, first of all, often those contracts are actually made in the context of the laws of the country at the time. But the second point I make is much more important, that actually these treaty principles only exist because Parliament said they exist. It's the treaty principles that we're talking about defining. So
they exist because the courts said they exist, and then Parliament chose to interpret the court's decision and put that into legislation.
And subsequent to that...
So the courts, which were the independent, neutral third party in this, or as close as we can get to a neutral third party, they were the ones who ultimately defined those treaty principles. The Parliament then decided to take that decision from the courts and put it into legislation.
And subsequent to that, the Parliament put them into legislation and across a whole lot of other statutes, which has affected the life and the rights that people have in this country every day. So you can make the argument all day about contracts and whether the courts are the right arbiter, but what I come back to is the question of whether or not it delivers a constitutional setting that gives equal rights, respect and dignity to each human being in this country. And what they've done clearly hasn't. And when the best example you can come up with of it working anywhere else in the world is, Canadian reserves.
That's your interpretation of the treaty, and we're going to get to that in a couple of minutes. I'm interested in this process with the referendum too. So you're proposing a referendum whereby all New Zealanders vote, all New Zealanders have an equal vote. But again, that fails to recognise that the treaty was signed by two distinct parties, right? You have iwi and hapu on one side, you have the Crown on the other, and when you look at Māori in the context of New Zealand's population today, they are the minority. So if a Parliament of the day was to pass principles, would it not be more appropriate to have two separate referenda, to have one whereby tangata tiriti vote and a separate one recognising that Māori were a distinct party, or iwi and hapu were a distinct party, a separate one whereby Māori vote independently.
But doesn't that just tell you everything that is wrong with this current conception of the treaty?
It tells you that there were two distinct parties that signed the treaty.
It tells you that indefinitely New Zealanders will be divided into two collectives decided by ancestry. Something that I'll say it again, and I think after the examples you provided, I can confidently say it's never worked successfully anywhere else in the world. The idea that people should be identified primarily by their ancestry, primarily by their ethnicity, their race, that is not a successful way to run a country. It creates enormous practical impediments to actually getting on with solving the tangible problems that New Zealanders have around health and housing and education and the economy. So we can play this game all day, sure. If you want to say that it has to be done by the courts, that this is the logical result that they've come to, then yeah, sure, you can have that. But my challenge to you is, where in the world does it work? And where is the place in New Zealand
Sweden?
for people? Well, it doesn't though, it doesn't. I mean, that's the best argument you can come up with, but actually, the places where it's been tried have been disastrous.
Yeah.
So, well, sure, but if you want to, and then even let's just say for a moment that your example of Sweden is a good one. I doubt that you'll find it is, but how in New Zealand is this supposed to work? Do you really believe that it's a good idea to say that forever and a day, and in eternity, there's going to be two groups of people? And going back to your question about the the referendum, again, you're assuming that all people have the same view. Actually, I start from the basis.
No, I'm not. I'm assuming there are two distinct parties, which is clearly what the treaty was.
Which are defined by ancestry, and that's what I'm opposed
to. Defined by iwi and hapu, who were Indigenous people of New Zealand. Who developed your treaty principles?
It's developed over several years, involving a lot of conversations with people, some who'd actually been past employees of the Waitangi Tribunal. And as we got to the point of the election, we had a pretty clear idea of where it should go. Subsequently, as I became Associate Minister, was turned over to the Ministry of Justice and ultimately the Parliamentary Council Office, Parliament's lawyers who draft these things.
So let's have a look at Principle 2, because I think much of the opposition to your principles at the moment seems to centre on an argument that they don't actually reflect what the treaty itself says. So this is Principle 2, and I know there's an argument that says that your principles are inconsistent with the spirit, the intent and the actual text. Now, many legal scholars and experts would say that Article 2 of Te Tiriti specifically grants Māori tino rangatiratanga over their lands, over their fisheries, over their taonga. Your principle here says that if those rights, quote, differ from the rights of everyone, then they're only recognised in the context of historical treaty settlements. So do you accept that your principles do not include a guarantee of Māori-specific tino rangatiratanga?
No, because they guarantee self-determination to everybody. And I think where there's been some confusion, or at least some people have, I think, mistakenly opposed this legislation, is that they believe that somehow you're going to have your mana or your reo or your culture taken away by this bill. The reality is this protects everybody's right to express themselves and be themselves, be Māori, but actually just recognise that we're now a multicultural society with people from many different places who are each trying to live in their own way. And I always give the example, there's one area of policy where the iwi chairs forum and ACT strongly agree. There's probably many, but this is the only one they've written to me lately to explicitly say it. And that's charter schools kura horua. Interestingly, the original name of the policy was partnership schools. And what it allows you to do is say, look, if you want to run a school in your way, that's rangatiratanga. There's the tino rangatiratanga. You can run your own culture, but it's not just Māori, it's also Pacific, it's also military style, it's also people worried about neurodiverse kids. That is self-determination for all people, and you can apply similar arguments across healthcare and social housing and so on.
The point of your opponents, though, is that nowhere in the treaty does it actually guarantee everyone that level of tino rangatiratanga, that it specifically includes a carve-out for iwi and hapu.
Well, it said it would give tino rangatiratanga to all the people of New Tirani, all the people in New Zealand. Now, of course, most people say, well, clearly that meant just the chiefs that were there in 1840.
Right. So
I think
it means all people.
I think it should mean all the people of New Zealand.
You think it should mean? You think it should mean? But do you think that's what it meant?
Well, the courts like to tell you.
No. What do you think?
Well, I think it should mean. I think it should mean all the people.
My question is, what do you think it actually meant?
Well, I think it should mean all the people.
Sorry, I'm not asking what you think it should mean. I'm asking what you think it meant.
Well, I suspect, I don't know. Nobody knows for sure. The courts have told us that it meant only Māori. The courts have told us that we now live in a country which is divided by ancestry into two collectives.
Okay,
and that doesn't work. So here's what it should be.
So the line you quoted Te Tiriti there. So ko te kuini o ngā arane ka whakarite ka whakaai ki ngā rangatira ki ngā hapu ki ngā tangata katoa o New Tirane, New Zealand, right? Ngā tangata katoa, and you've interpreted that as meaning all New Zealanders.
All the people of New Zealand, yes.
So, but I mean, you're giving us an English translation of a Māori text there, but of course we don't need the English translation of the Māori text because the Māori text was based on the original English text, right? So what does the English text of Article 2 of the treaty say?
Well, you've got it in front of you. Why don't you read it?
Well, I mean, so this comes to the heart of your argument, right? So really we're looking to see whether or not the English text guaranteed all people in New Zealand, tino rangatiratanga, or just iwi and hapu.
And you're going to read out that it says that they're going to protect the chieftainship of their lands.
I'll read it out, just because, I mean, you've given us an interpretation of the Māori text, but here's the English text upon which the Māori text was written. Her Majesty the Queen of England confirms and guarantees to the chiefs and tribes of New Zealand and to the respective families and individuals thereof the full, exclusive and undisturbed possessions of their lands, estates, forests, fisheries and other properties which they may collectively or individually possess, so long as it is their wish. That's tino rangatiratanga for Māori, a specific carve-out for Māori, not for all New Zealanders.
No, I understand that's what it says, but equally everyone tells you you've got to use the Māori text because that's what the signatories understood.
But interpreting the Māori text, when the Māori text is based on the English text, shows that clearly it's a carve-out for Māori, not for everyone. That's what the treaty says.
It's a very cute argument, Jack, but just to remember...
Well, it's actually an argument based on the treaty, right? And whether or not your principles actually reflect what's in the treaty. And you say that the principles are for all New Zealanders, and clearly the treaty says this is for Māori.
No, your cute argument is that we must listen to the Māori text because it's the Māori text that it was signed, it's the Māori text that was that the British were the proposers of it, therefore it should be the Māori interpretation that is used, and then as soon as convenient you say, oh no, actually no, we'll go back to the English text.
And your cute argument is that the legal scholars have interpreted the Māori text as meaning one thing are wrong, even though the Māori text was based on an English text which very clearly shows that the carve-out was for Māori, not for all New Zealanders. Now, there's one piece of regulation...
And once again, where does it get you? Where it gets you is to a New Zealand where there's a set of rights reserved for one group of people based on ancestry and not for another.
See, this is what you want. So this is your point, though, right? This is what you want the treaty principles to say, but actually the point is that they differ from what the treaty itself says.
It's ultimately not about what I want. It's about what's consistent with liberal democracy.
Do you accept that,
What's consistent with the set of rules that work around the world.
I understand. I mean, that's why we have the Bill of Rights, right? But do you accept that your principles, as you've defined them, differ from the text of the Treaty of Waitangi?
No, they're based on Te Tiriti of Waitangi, the one that was actually signed by the chief and the one that we're told we have to take seriously.
Except that I've just shown you though that your definition is inconsistent with that. Now,
with the English version that everybody says you're not supposed to use. So cute argument, but
your English language interpretation of the Māori text differs from Māori legal scholars, and if we instead of taking your interpretation of the Māori text, if we go back to the original text upon which it's based, it's pretty obvious.
The difference is mine's based on the Māori text and consistent with liberal democracy.
Well, mine's arguably based on both. Anyway, so Section 6 of the Ngāi Tahu Claims Settlement Act says this, quote, in fulfilment of its treaty obligations, the Crown recognises Ngāi Tahu as the tangata whenua of and as holding rangatiratanga within the takiwā, so the catchment, of Ngāi Tahu whānui. So under your principles, do you accept that Ngāi Tahu has full sovereignty over 90% of the South Island?
Well, we've said that we're going to accept, or we're not going to mess with treaty settlements, so you're required to follow those. And of course, I'm not going to be the one that tells everyone exactly what it means. Funnily enough, I think that's why we have courts. However, that would be a plain reading of what it says.
Right. So Ngāi Tahu, tino rangatiratanga over 90% of the South Island, according to your principles.
Well, again, that's what a previous government signed up to in a treaty.
It's a pretty significant. I mean, to accept that via your interpretation of the principles, that's a pretty significant finding.
Well, it is because, unfortunately, that's the settlement that's in place. Do I agree with it? I'm not sure I would have put it that way. However, Parliament signed off, and we've been very clear in this legislation that we're not going to interrupt or in any way mess with treaty settlements. So that's where you land.
What are the implications of that then? For Ngāi Tahu having tino rangatiratanga over 90% of the South Island?
Well, it's many of the problems that you'd expect to come out of the current principles of the treaty, which have been expanded beyond treaty settlement to the entire society. But what the implications of that will depend on different case law, and it depends what the question in front of you is at a particular time. What I can say is that it's inconsistent with the idea that all people who live in the South Island, many of them, most of them, it's the only home they have, and you have, through that treaty settlement, as you read it, a set of rights that are inconsistent with liberal democracy and equality before the law. That's a shame, but that's where they're up to.
But are consistent with the treaty settlement that you say we have to uphold, and arguably, in the eyes of some at the very least, consistent with the treaty that was signed between Māori and the Crown. Are you open through the Select Committee process to changing the definition of your treaty principles?
Yeah, I mean, that's part of the reason, right? We said we should listen, and I believe that as people get to see them, as you noted in your introduction, almost by a ratio of 2 to 1, New Zealanders support these principles. And that the democratic process is the right way to sort this out. I think one of the most important things that's happening here is that instead of having a relatively small group of New Zealanders in the form of the judiciary and the tribunal and so on deciding what laws we must all live under, each and every New Zealander has the right to make a choice about how they see the Treaty of Waitangi and what sort of constitutional arrangements they would like to live under. And that's the real difference here. You can have all of these arguments about what the courts found and what the versions meant, but actually what I'm saying is it gives us equal rights, and that's absolutely critical to the prosperity of people in any society. And second of all of the people who have to live under this law have a right to say what it means to them. Yeah. That is why there is so much resistance. And I think one of the most interesting questions about this whole debate is why? Why are people so het up about a bill that they all say won't go anywhere? The reason for that is that it has gone somewhere already just by introducing those two simple ideas, equal rights and an equal right to have a say. And what I say to people, if you doubt it, you can make up your own mind at treaty.nz. We've laid out the argument for this bill as well as anyone can, and the more people read it and the more they see it, the question is, okay, so what's actually wrong with the New Zealand under this particular law? It takes nothing away from Māori. It gives everyone equal rights. If anything, it increases the mana of the treaty by making these principles something that the whole society agrees on. The question, I think, for people who oppose it is actually what's not to like.
I went through Paul Goldsmith's cabinet paper, which is considering a separate bill to remove references of treaty principles from legislation, and it includes this advice from officials, quote, "Many treaty settlements and related agreements were negotiated and agreed in the context of current legislation, including relevant treaty provisions." That's to say that many treaty settlements occurred in the context of agreed jurisprudence at the time, and to retrospectively impose a definition of the treaty principles, which may not be supported by many of those iwi who have signed treaty settlements, could threaten the enduring status of those settlements. Is this worth doing if treaty settlements have to be renegotiated?
Well, I don't believe that they will be. All law exists in the context, all contracts exist in the context of the wider laws of New Zealand.
But that is the advice from the officials, though.
What's interesting about so much of this interview is how easily people question the idea that a parliament elected by the majority of New Zealanders shouldn't be able to make laws that are consistent with the rule of law.
The argument I made was that you, as a Minister of the Crown, arguably should not be defining the treaty principles, given the Crown is one of the concerned parties in the treaty, and that actually the courts are a much more appropriate place to define those treaty principles because they are a neutral third-party arbiter. We're running out of time.
Except I'm not. Parliament is the democratically elected body of New Zealand making the laws people need to live under.
And the executive is the representation of the Crown, as opposed to the courts.
Yeah, but
we're not. Conflict of interest.
It's the Parliament that would pass the treaty principles.
Do you reckon your coalition partners have acted in good faith during this process?
I think they find it exceedingly difficult. But hey, look, our coalition is very robust. We work together on a whole lot of issues. This is one where there's some disagreement, and I think it shows why you need an ACT party. This is a difficult conversation. A lot of people say, oh, well, why even have it, work on the economy or something. I say this is foundational to solving our other problems. I know it's difficult. I know there's a lot of people who are uncomfortable about having this conversation, but I think it's also becoming clear when TVNZ's polling says 46% of people say they feel that the country is divided by ethnicity or ancestry, that the New Zealand we like to think of is no more. And we need to have an honest conversation about how that's happened in the last 50 years. This interpretation, no matter how legally erudite, leads you to a place of two different collectives based on ancestry, something that in spite of your examples of somewhere in Australia or Canada, has never actually been a success.
What's your long-term plan if this doesn't pass?
My long-term plan is to always stand for equal rights, a Treaty of Waitangi that gives us equal rights, and a democracy where everybody can have a say on the rights that on the laws that they have to live under. Now, this bill will go through. It may be that my partners will see the logic of it and change their mind. They are, after all, politicians, and their job is to listen to voters. But if that doesn't occur, then I think where we get to is, okay, look at something like, say, homosexual law reform. First bill in the early 70s by Venn Young, became legalised in 1986. At the time, I'm sure people said, why are you even bothering this? It's a waste of time. Today, we don't even question that part of our legal arrangement. And one day, we'll get to a stage where people say, yeah, people used to make all these legal arguments and say it's a partnership. But eventually, we realised that being separated into two different racial categories was a dumb way to run a country. Now, we're a country with equal rights, and the principles of our treaty. The government has the right to govern. The government protects everyone's rights equally. And the government gives all people equal rights before the law. And we will be a much better country and so much more able to solve all our problems, whether it's health or housing or education or the economy, when we have a society based on equal rights and respect and dignity for each human being, instead of this crazy legal invention that's come up over the last 40 years.
We'll let you get a limb sit.
Thank you very much.
Thanks for your time. We appreciate it. David Seymour.